Thank you very much, Director, for that very kind introduction, and thank you to all of you for the welcome that you've given me. If there was a problem with the microphone, it is entirely of my doing. I had my roving mic switched on. This is why my 4-year-old granddaughter normally has to show me how to use the remote control when I want to watch television. It's a great honour to be invited to come here today to give a speech at the Conference on Executive Power, and a particular pleasure for my wife and myself to visit Utah, the first time that we've been able to do so, and to visit a city that at 4,549 feet above sea level is 4,540 feet more above sea level than the one that we live in the Netherlands. Now, I'm going to take the title of The Powers and Privileges of US Presidents Abroad with a certain amount of artistic license. And I do that for two reasons. The first is that I am a practicing judge, and therefore I think it's not appropriate for me to be too specific about any one country. But secondly, I'm afraid that, how can I put it tactfully, when English people have tried to tell Americans how to run their affairs, it hasn't always been an unqualified success. And I'm not going to try and repeat today the mistakes that George III and Lord North made a couple of hundred years ago. So I'm going to look at the powers and privileges of a US president abroad in terms of the powers, privileges, and rights of heads of state in general when they are outside their own territory. And there's a good reason for doing that, and it is that international law necessarily has to treat all heads of state in the same way. So the powers and privileges of a US president abroad are essentially the same as those of the president of China when he goes abroad, or of the two captains regent, who, as you will know, are the joint heads of state of the 32,000 people of San Marino, the tiny republic in the Italian mountains. And therefore, with that more general view in mind, I want to start you off with a love story. 130 or so years ago, a young lady called Miss Miguel, a resident of my hometown in Britain, Cambridge, met and fell in love with a handsome stranger who went by the name of Albert Baker. At some point, either just before he proposed marriage to her or just afterwards, she discovered that Albert Baker was not in fact Albert Baker at all. He was Abu Bakr, the Sultan of Johor, one of the states on the Malay Peninsula, and at that time, effectively an independent country under British protection. Now, at this point, it's just the perfect script for Disney to offer to bid for the film rights. But unfortunately, everything then went wrong. Abu Bakr let down the unfortunate Miss Miguel. He reneged on his promise of marriage. Unfortunately, it would appear that he left her with rather more than just memories and disappointment, as her son, Albert Baker, whose father was unknown, ran a tobacconist in Cambridge for many years afterwards. And she sued him for breach of promise of marriage, an action which was still possible under common law in those days. And his lawyers pleaded that he was a foreign sovereign entitled to immunity from the jurisdiction of the English courts. And that claim was upheld, first by a trial judge and then in the Court of Appeal. The action was dismissed on the grounds that he was a foreign sovereign, and he remained a foreign sovereign even if he was in Britain, incognito, and posing as an ordinary individual. Now, Disney would not have liked that bit at all. Now, how does that have an effect on the way in which we look at heads of state immunity today? I'll come back to that in just a minute. Let me, before I do, make two preliminary remarks. The first is that heads of state come in many different shapes and sizes. There's a greater variety than we perhaps realize. Now, there's the obvious difference between monarchies and republics. Most of the people in this room are citizens of the United States, where you have a long-established tradition that the president can serve no more than 2 4-year terms. I, on the other hand, am a citizen of the United Kingdom, where the current Queen had already been on the throne for several years before I was born, and has just become, last week, the longest-serving monarch the United Kingdom has ever had, surpassing the record set by her great-great-grandmother, Queen Victoria. But you also have the difference between heads of state who, like the American president, are very much the chief executive, the most powerful person within the country, and heads of state like my own, who are largely constitutional figureheads, real power residing elsewhere. And you have somebody like the President of France, who shares power with a Prime Minister who may indeed be of the other political party. That has happened many times in modern French history. You have even more exotic examples than that. Malaysia is an elected monarchy, where the 9 different royal families elect one of their number to be head of state for a term of 5 years. Switzerland has no one individual as head of state. It has a collective presidency. The 7 members of that collective presidency are jointly the head of state of the country. Her Majesty the Queen is not only head of state of the United Kingdom, she's head of state of 15 other countries as well. And as head of state of Canada, for example, she has a quite different role from the role that she has as head of state in the United Kingdom. And finally, you have His Holiness the Pope, who also counts as a head of state, at least when he visits most countries, though whether that is because of the existence of the tiny state of Vatican City in the middle of Rome, or because of his position as head of the Holy See, which in its own right has international personality, nobody has ever fully sorted out. But you had an interesting example of the importance of that when the previous Pope, Pope Benedict, paid a formal visit to the United Kingdom 5 years ago. A group of people who acted for victims of sex abuse within the Catholic Church wished to bring proceedings against the Pope, arguing that as a bishop, he had failed to act on reports of sexual abuse within his diocese. And the legal advice that they apparently received is that this would not be possible because as a foreign head of state, he had absolute immunity under the principle laid down for the first time in Miss Miguel's case against the Sultan of Johor. So that's my first point. Watch out for the sheer variety of heads of state that you have to cope with. The second is just to highlight the distinction here between international law and the national law of any given state, domestic law, as we sometimes call it. Each state has very different arrangements for the distribution of political power and authority, the checks and balances on that authority, the control of the power of its head of state by its courts. To some extent, at least, in the English-speaking democratic countries of the world, that has been a progression over the last many centuries from the principle that the king can do no wrong, first laid down by Roman jurists in the 2nd century AD during the high point of the Roman Empire, but then developed in most of the European countries during the Middle Ages, and first attacked in Britain with the adoption of Magna Carta 800 years ago, and then very much adopted as a principle in the Constitution of the United States several centuries after that. But although it has a considerable antiquity, I was very struck by the fact that when David Frost interviewed former President Richard Nixon 3 years after Nixon's resignation, one of the most telling remarks that Nixon made was that he considered that if the president did it, it could not be illegal. He then admitted that other people didn't see it in the same way, which shows that it's possible to learn something from experience, if nothing else. Now, that development is a constitutional development, which has taken place in some countries and not in others. It's not a matter of international law. International law does not necessarily deal in those limits on the powers of a head of state. And the limits which a domestic constitution places on the power and role of the head of state will not automatically be given effect within international law, precisely because international law has to treat on a footing of equality heads of state who are absolute dictators within their own territory and heads of state whose position is very heavily circumscribed by the constitution of their own country. So what we are dealing with here is not the domestic law limits on the presidency. Of that you'll hear much more in the course of the rest of this conference. but the way in which international law treats the presidency and the role of the president abroad. And one point I would like to stress about that is that international law deals with this by way of rules, not simply by way of politics. International law requires each state to accord certain privileges and immunities to the heads of other countries when they visit. It's not simply a matter of discretion. And I think that's important because, especially in some of the United States case law, that is not always entirely clear. And it's not always clear for a perfectly good reason. In United States court practice, the tendency has been to accord immunity to a visiting head of state if the executive has asked the court to do so. And this gives the impression that it is a matter of pure discretion. It isn't. It is rather a matter of it's the executive, not the courts, which determines who is a head of state, and therefore whether that person qualifies for the immunities that international law requires. Now, on the face of it, the position in international law is straightforward. As the English court decided in the Miguel case, a head of state, a sovereign, remains a sovereign, even when they travel outside their own territory. And therefore they retain their powers as sovereign, they retain the privileges that they possess, and they are immune from local jurisdiction. It all looks very simple. In international law, it is never as simple as it looks. And one of the reasons for that is that there is no written text, no treaty dealing with the immunities and position of a visiting head of state. It is a matter of what is known as customary international law, and therefore covered by unwritten rules comparable to the common law in the United States or the United Kingdom. And therefore it is necessarily more malleable, more open to argument than a written text tends to be. So I want to look at 4 issues to do with the powers and privileges of a head of state abroad. First of all, who gets them? Who is a head of state for these purposes? Secondly, what are the powers of a visiting head of state? Thirdly, what are the privileges of such a head of state? And lastly, what is meant by immunity from local jurisdiction? Now, on the first one, who is a head of state, this is usually very straightforward. It's perfectly easy in the United States or the United Kingdom to establish who is the head of state. In the United States, it's never open to any doubt. In the United Kingdom, you do, of course, have both a monarch and a prime minister, and political power resides with the prime minister rather than with the monarch. Nevertheless, as a matter of social standing, there is no doubt about who is the senior of the two. As Margaret Thatcher discovered when she became prime minister, and in one of the very first functions she went to, she wore a dress that was very similar to the one worn by the Queen. And that caused a certain amount of embarrassment. And the next day, a very embarrassed private secretary from the Prime Minister's office in Downing Street, a man, had to ring his male counterpart at the palace and suggest that possibly they might discuss beforehand what their principals were going to wear. This wasn't an issue that had ever arisen before Thatcher's time. And the Queen's private secretary just said, "Oh, tell the Prime Minister not to worry. Her Majesty never notices what other people are wearing. So you may have the power, but Her Majesty decides who's going to wear what." But it can be more difficult in other circumstances. In federal states, you sometimes have claims that because the states within the federation have a form of sovereignty, their head is entitled to privileges abroad. A governor of one of the Nigerian states arrested at an airport in London while carrying a very substantial amount of cash and a gold-plated mobile phone, which must be something of a record in terms of tastelessness, claimed that as the governor of his state, he was a head of state and entitled to immunity. That was rejected by the English courts, as incidentally was an argument that the Sultan of Pahang, another of the Malaysian states, now part of the Federation of Malaysia, as is Johor today, that he was entitled to head of state immunity. He tried to rely on the Miguel case. No, said the court, in Miguel's time, Johor was independent. Now Johor and Pahang are part of a federation, and the head of state is the overall head of the federation, not the heads of the individual countries. There can, of course, be a problem if you have more than one contender for the position of head of state. In a case called Aristide in this country, La Fontaine and Aristide, the Circuit Court for the Second Circuit, if my memory serves me right, decided that former President Aristide, the exiled President Aristide of Haiti, was still the head of state of Haiti, even though he had been out of power and out of the country for over 2 years before proceedings were brought against him. But even that can be problematic. It may be that a state's choice of who it treats as the foreign head of state is wholly artificial. For example, after the Soviet invasion of Afghanistan in 1979, the Soviet forces installed somebody as president. It's doubtful whether that person would have been regarded as the head of state by most other countries in the world at the time. There is also the further difficulty that the immunities and privileges of a head of state also cover, for certain purposes, the immediate family of that head of state. Well, again, not particularly difficult if you are President Obama. His wife and his 2 daughters, if traveling with him, would also benefit from certain immunities and privileges. It's a bit more of a problem if you're the King of Saudi Arabia, with over 3,000 relatives who are entitled to the title of prince. In a recent English case, the Court of Appeal decided that just because you were a prince of one of the parts of the Royal House of Saud did not entitle you to any immunities when traveling in the United Kingdom. And I think the same position would be taken by the courts here. A more difficult case is what about somebody like the president-elect during the period between the election in November and taking office in January? Or, for example, His Royal Highness the Prince of Wales in the United Kingdom, who now carries out many of the day-to-day functions of the monarchy. Now, that has arisen in a number of cases. In the United States, Prince Charles was accorded immunity on the basis of a State Department recommendation when there was a riot at a meeting that he'd spoken at, and one of those who was arrested tried to sue both the local police and the Prince of Wales. But that was on the basis that he was there on an official visit and was in effect equivalent to a visiting ambassador. Whether the Prince of Wales would automatically receive a degree of immunity in the courts of this country is a different matter altogether. And strictly speaking, a president-elect, if he chose to visit another state during the period between the November election and taking office in January, is probably not entitled to any immunity at all, though it is likely that immunity of some kind would be accorded on an ex gratia basis or by means of a special agreement between the United States and the other country concerned. And lastly, there's the problem about former heads of state, former presidents. Whereas an incumbent is entitled to all the rights of the head of state, what do you continue to receive once you have ceased to hold that office? Well, for example, the courts in France held that a former head of state was not entitled to immunity if he or she was sued over things they had done in a private capacity. The former king of Egypt, King Farouk, was sued by Christian Dior because he hadn't paid for dresses that he had ordered while he was king for the benefit of his wife, Queen Farida. The Court of Appeals of Paris held that ordering dresses for your wife is a private matter, not one of the official functions of a head of state. I've never actually asked my wife whether she would take the same position as the Paris Court of Appeals about that. And in the Pinochet case in the United Kingdom, the House of Lords, the highest court in England at that time, decided that the limit on Pinochet's immunity that they imposed could be imposed only because he was a former president of Chile. Had he been the incumbent president, he would have had complete immunity from criminal proceedings in the United Kingdom. So there is a certain difficulty about who might qualify. Let me turn from that to what are the powers of a head of state abroad. It's important there to remember that contrary to what is popularly believed, there is no extraterritoriality when a head of state visits another country. The US Embassy in London is British territory, not American, just as the British Embassy in Washington is part of the United States. It may belong as a matter of title to land to the country that has its ambassador there, but it's not part of the territory of that state. In fact, the US Embassy in London doesn't even belong to the United States. It's rented from the Duke of Westminster. Apparently, Lyndon Johnson, when he visited London in 1967, was outraged that the United States was paying rent to a duke for its embassy in London, even though the rent is a nominal one. And he insisted that America should buy the freehold of the premises in Grosvenor Square. The Duke of Westminster is notorious for never selling land if he can avoid it. But he did say to the ambassador that he was willing to enter into negotiations for the sale of the freehold, but only on the basis that lands taken from his family in the 1770s and early 1780s in America would be restored to them. It turned out that this was the whole of North Carolina, and nothing further was heard about this particular transaction. So, a president of the United States visiting, let us say, France, and staying in the residence of the American ambassador there, is on French territory, which means that anything he does there necessarily involves the sovereignty of two countries, not just of one. And the general principle is that no state is entitled to exercise its sovereign power on the territory of another country, save to the extent that that other country consents. Now, in practical terms, there is no difficulty about a president of the United States, while outside the US, taking decisions about US domestic matters, and indeed that would happen all the time. So a president of the United States that takes decisions about whether or not, for example, to veto a bill, and takes that decision while he's visiting in an embassy somewhere in Europe, commits no wrong of any kind in doing that. But it would be more difficult if the action that he took involved a degree of interference in the internal affairs of the state that was his host. So when Charles de Gaulle, as president of France, on a visit to Canada in the late 1960s, spoke to an ecstatic audience and said, "Vive Quebec libre, vive, long live free Quebec," the visit was brought to a rather abrupt halt after that. He had taken an action that interfered in internal Canadian affairs and was considered by the Canadian government to be improper. And even if it's a matter of purely domestic policy back home, there might be circumstances in which what was being done was so contrary to the public policy of the host state that it raised a difficulty. For example, a visiting head of state who signed a warrant for the execution of a prisoner while visiting the United Kingdom, or indeed any of the European states, would be likely to have difficulty with his host government because the death penalty has now been abolished throughout Europe and is in fact contrary to the European Convention on Human Rights in terms of the obligations of those states. One last comment about the powers of a president abroad is that whatever the limitations imposed by the US Constitution on the US president's activity, or by English law on what the head of state may do when she is abroad, a head of state, as a matter of international law, has the power to bind their own state. They have powers to conclude international agreements. The statements that they make are attributable to the state. They are part of the policy of that state, and they may in fact be held against the state concerned. So, for example, when the French president in 1973 made a statement at a press conference about ending France's policy of atmospheric nuclear tests, the International Court of Justice held that that statement was a binding undertaking that committed France not to hold atmospheric nuclear tests in the future. Now, of course, if this president's action is obviously ultra vires under United States law, or whatever other legal system is appropriate, then that action would not be recognized by international law either. Every person knows that the United States president cannot conclude a treaty without the advice and consent of the Senate. But he can, of course, conclude something called an executive agreement. And while the limitation on the power to conclude a treaty, properly so called, is understood, the exact dividing line between what can be an executive agreement and what can be a treaty is perhaps a little more arcane, even to American lawyers, and certainly not something which will be readily understood by lawyers outside the United States. So again, there you might have an example of an action taken by a president outside the United States, which committed the United States in some way, even though it ran contrary to the limits imposed by the Constitution. Let me turn from that to the privileges of a visiting head of state. A visiting head of state is entitled to protection for his or her person and dignity. Now, protection of the person is fairly obvious. If you have a foreign president or king on your territory, you must protect them. You have an international law duty to ensure that they're not assailed, to take reasonable steps at least to prevent their being assassinated or attacked while in your country. And it's for that reason that it's always open to a state to refuse a foreign head of state the right to enter its territory. The United States is always at liberty, if it wishes, to say that no, Her Majesty the Queen or the President of France or the Emperor of Japan may not visit the United States, because the duty that would impose on the United States to protect them would be too great. That became an important issue in a case in Europe a few years ago. For states that are members of the European Union, any national of an EU country has a right of free movement throughout the European Union. So I, as a British national, can come and go in any of the other 26 member states of the EU pretty much at will. A Slovak group had invited the President of Hungary to come to the unveiling of a memorial in an area of Slovakia which had at one stage been claimed by Hungary during the Second World War. This was extremely controversial in Slovakia, and Slovakia refused the Hungarian president permission to cross the border to go to this unveiling. Hungary then brought a case in the European Court of Justice, the European Union's court, against Slovakia, claiming that there had been a violation of the president's right of free movement. And that court decided that there was no right of free movement for a head of state. A head of state was different from everybody else because of this duty of protection and the duty of respect which went with it. And for that reason, a state was entitled, as a matter of general international law, to refuse admission to a foreign head of state if it chose to do so. It would, of course, have to take the consequences of any damage to its bilateral relationship with that country, but it remained entitled to take this step. Now, it's not entirely clear how far the duty of protection of a visiting head of state goes. It can't be an absolute duty. You cannot completely guarantee the protection of anyone in this modern world. There was a graphic instance of that when President Clinton was visiting the United Kingdom in the late 1990s. He and Hillary went for dinner with Tony and Cherie Blair, the newly elected British Prime Minister and his wife, in a fashionable restaurant just south of the river in London. On the way back to the ambassador's residence where the presidents were staying, they had to cross the Thames. Unfortunately, their cavalcade got there just as the bridge was raised to allow a ship to sail upriver. The Secret Service guards around the president were absolutely outraged, and together with a rather embarrassed British policeman, went and ordered the bridge master to lower the bridge at once so that the president's cavalcade wasn't held up. The bridge master told them to go and get lost. Said his duty was maritime safety. If the president chose to come this way, he was just going to have to wait for the 20 minutes necessary before the bridge could safely be lowered once again. My father, who was a career merchant navy officer, when I told him this story, said, "And quite right too, you can't possibly have bridges being lowered when a ship's sailing through them. Terribly dangerous." Whether the bridge master's career flourished as a result of the decision that he took is another matter altogether. There has also been repeated problems about the right of the security men around a visiting head of state to carry, let alone use, the firearms that perhaps they're accustomed to carry with them in their own country. Dignity is an even bigger problem. The duty to protect the dignity of heads of state was at one time interpreted as meaning that even criticism in the press was unacceptable. Now that today is simply out of the question. Nobody would be able to suggest in the United States that given your constitutional protection of freedom of speech and freedom of the press, that a newspaper could not criticize a visiting dignitary, a visiting president or monarch when they came to the US, let alone criticize them when they weren't present in the United States. The exact nature of the duty to protect the dignity of a visiting head of state is therefore rather problematic. And it's arisen in particular in a case in the United Kingdom where a lady sued the then King Fahd of Saudi Arabia, claiming that she had been married to him at an earlier stage and that he had not made proper financial provision for her when terminating the marriage. I should say the account in the papers of the case appeared to show that several £million had been given to her, but this was apparently not enough to enable her to live in the style to which she wished to be accustomed. The king's representatives argued that in order to protect his dignity, the case had to be heard in camera and the press had to be excluded. But there is, of course, a general principle of English law, as well as a provision in the European Convention on Human Rights, that justice should generally be done in public. And the court decided that that principle overrode any concept of protection of the dignity of the head of state of a foreign country. I may say that after the king had lost that particular round, his solicitors instructed me to appear for him to claim immunity in the proceedings that were to follow some months later. This was the day before my wife and I went away on holiday. And contemplating a case that was going to be both interesting and possibly also quite remunerative, I went away on holiday with a rather lighter step than I might otherwise have done. Fortunately, I didn't act on that because the king died during the 2 weeks I was out of the country. And this is one of the few types of action that dies with the death of either of the parties involved. It can't be maintained against the estate of a former party. Lastly, there is the question of the immunity that a visiting president or monarch is entitled to. Immunity, and I should say also inviolability. There is a clear prohibition on any attempt to arrest or subpoena the head of state of a foreign country. And that's very straightforward. More difficult is the question of whether there are any exceptions to the Miguel principle that you can't even sue a foreign head of state. Now, at one time, there was, I think, a confusion in many of the cases in both England and America about the distinction between the head of state and the state itself. This was particularly true with monarchies because of the Louis XIV principle that l'état c'est moi, the state is me. In English law, for many, many centuries, you could not sue a foreign country as such. You had to sue the head of state. An action against Spain would be an action against the King of Spain as a matter of English law. Now, I don't think the American courts ever fell into that trap because it's obviously not something that works if you have an elected republic. But because of that, it's sometimes been suggested that the limits that you now have on the immunity of the state itself must also have led to limits on the immunity of the head of state. Now, that argument has so far been rejected whenever it's been tried, but it is particularly important in one area. Suppose the allegations against the head of state are allegations of particularly extreme violations of human rights, for example, crimes against humanity, actions such as torture. Now, it has been suggested that in those circumstances, because the conduct is so clearly prohibited by international law cannot require a state to accord immunity in respect of it. That has so far been rejected with a serving head of state. For example, an action against President Gaddafi of Libya, as he then was, in the French courts, for allegedly murdering some 200 passengers on board an aircraft. Not, by the way, the Pan Am plane that crashed at Lockerbie, which was the subject of different proceedings. This was a case about a UTA plane that crashed in the African state of Niger and had a bomb planted on board it. That action was rejected by the French courts on the grounds of Colonel Gaddafi's personal immunity as head of state. And in the Pinochet case in the House of Lords, the House maintained that even with allegations of torture, a serving president would enjoy immunity. But it went on to say that a former president would not. And the precise limits of that exception have yet to be fully worked out. Moreover, although a head of state is entitled to immunity from the jurisdiction of the courts of another state, because one sovereign may not exercise sovereignty over another, there is nothing to stop an international court taking proceedings against a serving head of state. The Nuremberg Charter expressly provided for that. The Statute of the International Criminal Tribunal for the former Yugoslavia did the same. And President Milosevic of Serbia was actually indicted by the ICTY while he was still president, although it was only after he was deposed as president that he was arrested and handed over to The Hague. As you probably know, he died before his trial was completed. He was, in fact, for a while, a neighbour of ours in The Hague, because the prison where the ICTY defendants are held on remand is about half a mile from our apartment. And the statute of the International Criminal Court expressly provides that a head of state has no immunity from the ICC. And that has been applied by the ICC in the various cases involving the president of Sudan, Omar Bashir, who's been indicted on a number of charges, as well as the president of Kenya, President Kenyatta, and President Gbagbo of the Ivory Coast, who was again indicted while he was still in office. Now, there is a difficulty there as to quite where that leaves states that are not part of the ICC, such as the United States. For those states that are parties to the ICC statute, clearly no state is in a position to claim immunity for its head of state in front of the courts of another country that is also an ICC statute member, if it's a question of handing the head of state over for trial at the ICC. Also, in the case of General Bashir in Sudan, it was the Security Council of the United Nations that referred the matter to the ICC, Sudan not being a party. And so it's possible there to argue that the duty to comply with the decision of the Security Council overrides any question of immunity that might arise. But it is, I think, much more difficult to see how the immunity which international law accords to the president of a country that is not an ICC statute member and which has not been the subject of a Security Council reference would have to be dealt with. I think that remains a question that is open to argument in the future. Let me just offer 3 thoughts by way of conclusion. The first is that the old confusion between the state and the head of state is, I think, a thing of the past. Those of you who are studying law or who go on to study law, you may still find that some of the older cases are a bit baffling on this point. But I think today the justification for having an immunity for the head of state is much more a functional one than a dignified one. The head of state is entitled to immunity and protection because otherwise it would be impossible for them to travel abroad and to do the job of being head of state at the international level. And that justification, my second point, is actually one that matters. Imagine how much more difficult the limited achievements in the peace process in the Middle East would have been if the heads of state had not been able to travel, for example, to the Norway meeting or to the Camp David meetings here. The fact that a president or a king is able to travel for the purposes of a summit meeting, and the same immunities for these purposes would apply to a prime minister, has been an important part of diplomatic relations and peace negotiations for many decades, since Woodrow Wilson's famous trip to Europe while president for the purpose of attending the Versailles Conference at the end of the First World War. But, and this is my last point, we cannot overlook the fact that there is increasing pressure in international affairs to call to account those who are accused of the most serious crimes under international law, crimes such as torture, genocide, crimes against humanity, war crimes. And that sets up a tension with the obligation of protection, the privileges, and the immunities that have to be accorded to a visiting head of state. And I think that that tension will continue to be a problem in international law for some considerable time to come. Thank you all very much.